So thanks so much for joining today. We're looking at covering the last learning outcome in this particular unit, which is law for accounting. This is going to be a bit of a theoretical one, keeping in mind we need to be aware of some of the basic bits around, let's say, the laws affecting things which are related to data protection. We're going to be looking at something like intellectual property rights. We're going to be also looking at employment law and legislation. In some cases, some of us, when we look at offering accounting or management and financial accounting services, we do get to see that, payroll is something which is sometimes de facto understood as that this is also something that is going to be a part and parcel of the accounting and accounting practice. And obviously, we see this as a bit of a value addition when we get to see that some of our clients, small, medium, big enterprises, whatever may they be, they also sometimes look at outsourcing the payroll services to us. So when we look at setting up and managing payroll, either through a software or, most of us do it through Sage 50 or, some of the softwares like Xero or QuickBooks, then in those cases, at least you need to be aware of some of the basic legislation which surrounds employer and employee relationship. And that is all covered under what is the, let's say the impact of, or basically the remit of, employment and legislative laws. So we'll be looking at some bits of that today in the assessment criteria 4.3. And then we'll go into a bit more detail in terms of understanding why is intellectual property important, as we do get to see that a lot of our clients sometimes come from the gig economy, which means they are businesses which are either providing services or software related organizations or organizations which are predominantly providing services over the cloud. And in some cases, when you have clients like these, wherein the content or the material that they basically provide as a product or a good or a service needs to be protected. And in those cases, we need to be aware of, things like intellectual property rights, what they are, what are the various different, types that we can look at under the IP, which could be things like copyright. We look at patents, we look at, trademarks. So we need to be aware of, and these are some of the ancillary services we might or we might not offer, and our prima facie functions tends to be, looking at accounting and payroll and, basically auditing side of things. But sometimes you'll have clients who will have some of these as, their requirements, and having a knowledge on some of these activities or, areas are very closely related to accounting. So it might be good for us to understand how they work, where they apply, and sometimes when you include them as goodwill, sometimes when you include them as copyrights or trademarks or costs which are, spent on getting patents or obviously, applying for patents or applications and things like that would be covered in the balance sheet or in the asset list of the client. And that is where this usefulness of this particular learning outcome would come in for today. So this particular learning outcome focuses on building our knowledge about, it talks about understanding. So we are not looking at applying anything anywhere. It is primarily going to be knowing and to know. That is the main area of the understanding of this particular topic that we are going to cover. So it is looking at understanding the areas of law which can affect business and professional operations. And when we dig deeper slightly into what we are going to be looking at covering, it includes things like data protection, which applies pretty much all across today when you handle clients' data or when you have documents and data which is available or made available from the client, or you handle or manage it on behalf of the client with requisite permissions. We will look at intellectual property, as I mentioned, impact of employment legislation in particular, and then last but not the least, go into a bit more detail to look at a bit of an assessment on the importance of why intellectual property rights are important, are becoming increasingly important for businesses which derive their revenue predominantly from services or services-based industries. And in those cases, the idea would be to try and take up an example and understand where that might apply. So a fair amount of indicative content in this particular learning outcome that we are looking at covering, but it will generally revolve around these three broad areas: data protection. So we will be looking at the Data Protection Act of 1998. which has been further revised with the implementation of General Data Protection Regulation Guidelines, which is called the GDPR in 2015-16. And obviously, when we were a part of the European Union, obviously there were 2 years given to small businesses, all businesses essentially in the EU, to be able to make sure that they are compliant, with the GDPR guidelines. And we have the UK version of the Data Protection Act, which was revised in 2018 to include what is called the GDPR, and we will look at basics of what that means, what were the changes which applied, and how data can be shared, how data can be removed, what is the importance of the data protection officer, and in some cases that is all dovetailed into one, which is us when we offer the services. So we have know your client data, sheets or declarations that we take. And then when we take those declarations, what we normally do is we maintain files of, personal information. And in those cases, when that file is maintained, we need to make sure that we are complying with the data protection laws in terms of people with authorization, access at a particular level, have access to those sensitive data, and what all will that be covering under data protection. Intellectual property, there are lots of areas under IP. This is a specific area of law. A lot of people are looking at specializing towards IP law, and it's a big business, big ticket item, especially in Western economies, wherein a lot of services, products, goods which are being traded, obviously developed by companies or manufactured by companies, they apply for patents. We are very well aware of, from the news and the market when we see, patent wars erupting between Google and Apple, Google and Samsung, or Samsung and Apple. And recently, you must have seen in the news, Apple versus Epic Games, because they quietly removed, the Fortnite version of the game from the Apple Store. So obviously, lots of places where intellectual property is now becoming important, especially because as things become data-driven, they become cloud-driven. There are bases through which this becomes applicable at some level or the other. So we look at patents, copyright, designs, we look at trademarks, and they are all covered under what is called the Intellectual Property Right Acts. Okay, let me delay this in terms of try an hour so the computer does not restart. And then lastly, but not the least, we will look at some of the basic employment legislation that we need to be aware of, and we'll go into a bit more detail. So there are a couple of backup slides that I've created towards the end of this presentation. We've got about 65 slides. We're not going to go through all the slides today, but there are some backup slides towards slide 44 onward. We basically talk about some of the bits that you would want to get additional information on in terms of the ACAS procedure, the code of conduct, how disciplinary action and other things need to be applied, and some of the laws, that we need to look at in a bit more detail so that you have a bit of journal, this is primarily for information and general knowledge, that you'll be able to go through some of these slides and then look at them for additional reading or understanding. And they are given, as under the heading of backup slides after the main presentation. So things like discrimination, when we talk about, we'll be talking about a lot of different acts, and they are going to be covered in a bit more detail, specifically, towards the end. Now, the reason I've not covered them in detail within the presentation is because when we look at the remit of accounting or financial or management accounting, I think our remit is going to be related to mostly, financial transaction side of things, but to a certain extent, with most accountants now taking on the function of or providing the function of payroll as well to smaller clients or some of their clients. So the basics of this understanding needs to be done, and that is why you would see that this has been included predominantly in the in the module itself. So at some stage, you cannot say that, if I say my primary profession, I'm an accountant by profession, but the moment I say that I have maybe 55 clients who for which I do the payroll, and if I have no understanding of the basics of the employment and legislative acts and some of the HR side of things, then I won't be able to offer these services to some of the clients, which brings in additional revenue to me. So it's very difficult to kind of, separate the payroll side of things from the accounting and financial side of things that you provide as services to your clients. So in most cases, over a point in time, most businesses which are small or have less than 10 employees, most of it is maintained at the accountant's end, and you are, if you like it or not, you'll have to look at doing payroll, and that is where this particular outcome, learning outcome 4.3, the assessment criteria 4.3, the impact of legislation relating to employment would be useful, although it's a specialist field, but at least it'll give you an overview or a bird's eye view of what are the basic things that you need to be aware of specifically while you set up payroll or you deal with payroll for some of your clients. We'll start off with some basics in terms of looking at some key terminology and just understand broadly the terms which are going to be coming again and again in the 3 or 4 assessment criteria we'll cover. So I've started off with something called data protection. Now, we've all heard about data protection. So when I say data, there are 3 forms of data, if I may say so. You normally see data. Data at some stage when it is processed becomes information, and information when it is further processed using some sort of systems can actually become source of knowledge. So when we look at data, data resides in 3 different formats. So when you have basic or binary data available, which could be an application form, a client interested in signing on and taking on your services, they fill up a basic form on your website. That basically is data. But when you discuss that with your client, you understand the requirements in a bit more detail, and you start exchanging some part of that data, which could mean that you get a company's incorporation certificate, you get a previous accounts, then you start to get some information. And that information is synthesized data in some sort of format or report, which allows you to extract the golden nuggets or the pieces of information which you require to be able to set up the client as a new client on your side. And then once that information has been fully processed and processed as per your requirements in terms of looking at, okay, we need to look at getting hold of this, which is client information. We need to get hold of previous year's accounts. We need to look at authorization from HMRC to be able to represent as an agent. And then you have some other bits and pieces that you would go on and keep doing, and they would then be sources of knowledge. So that information would be converted into further meaningful data or information, and that would at some stage be called knowledge. So for example, you might say, I have a client where they are into this particular business, they provide these services, have so many offices, have so many employees, this is their turnover, and that would be actually knowledge that you have when you look at processing that from raw data or data that has been made available through public domain. So when we talk about this in some shape or form, the protection law, the data protection law in the UK in general and in most countries, ask you to comply with certain rules and regulations. So when we talk about key pieces of information which are normally stored by business, you might be having information about your client, maybe the accounts, bank, the personal information, and that will all need to be protected. Now, if you decide to share that with third parties, you decide to use that information for marketing purposes, you will have to seek permission to be able to use that information, for other than what has been already agreed under the contract. Now, the Data Protection Act, when it was introduced in 1998, basically had 6 important principles. So these 6 important principles very closely relate to, the 6 accounting principles that we generally look at, and they kind of mirror somehow some of the basics, when we look at morality side of things. So when you collect data, when you, get data, it has to be processed fairly. You have to process that data in a way wherein it's transparent. If you're asking or seeking some information, then the user should be informed that this information is going to be taken or is going to be sought when you're browsing the website. Or for example, if you record a call, sometimes you would get to see that, it'll say these calls are recorded for training and monitoring purposes. Now, this is a message which basically gives you an important piece of information that the call is being recorded. And if you're not comfortable with the discussion that is going to be recorded, then you have the right to be able to state that, okay, no, I'm not comfortable for this, the contents of this call to be recorded. And that would mean that the other party in this case would have to look at, switching off their recording in some cases and then do that discussion. Or in some cases, client prefer to do that on a face-to-face basis. So these 6 principles basically ensure that the data being collected, which is personal data about business or the individual which is being collected is collected in a very fair way. It is being stored and has proper, let's say when I say if you collect data electronically, then it has to be stored, and you're responsible to ensure that the data does not fall into wrong hands. If it's collected as paper or as documents, again, they have to be kept aside in a lock and key method so that people with appropriate access should have only, should have restricted access, or people with permissions at appropriate level should have access to it, and it should not be accessible to everyone. The other thing it mandates is that when you collect data, you have to draw a line in terms of how much data you need to collect, what is required for the business. And, in some places, when you look at this, data needs to be updated. So when you look at data which is collected by your surgery, data which is collected by your bank, or data in certain cases which is, periodically collected, one of the other responsibilities on the agency or the company which collects that data also is that they need to keep that up to date if it is something which is related to financial side of transactions, or in general that data is to be used going forward for various reasons. And then last but not the least, once the data has been utilized, or once the usefulness of that data has gone away, then the data should be securely done away with. That means it should be destroyed, it should be removed from the system if it's stored electronically. And the GDPR side of things basically makes that possible. As a user, they can, if you're collecting data about, website details, or when they visit, or if you have details about a client and their details in terms of financial transactions, then under the GDPR, the person can actually write to the DPO, Data Protection Officer, and ask for that information to be removed because you're no longer providing those services. And all they have to do is basically write a simple email, and that should allow them the access to the DPO. The DPO then would have this as a written consent and would be then liable to remove that data from the system or destroy that data electronically from their, PCs or laptops. And this falls under the remit of what is called the ICO, Informationers Commissioner's Office. And, obviously in some organizations, when you look at collecting data and data that is sensitive, personal, which look demographics of the client or the business, then in those cases, what you'll have to do is make sure that you have the ICO registration, which allows you to collect this data and you're meeting one of the legal requirements in terms of collecting personal data, specifically things like passport, nationality, religion, beliefs, other bits related to educational documentation or business documentation, and that would be all done under the Information Commissioner's Office subscription ICO, and that basically covers what relates to the Data Protection Act that we now see in the current terms. So the other bit that I want to look at briefly defining is intellectual property. Now, when we talk about IP, I'm pretty sure everybody has heard about IP. And we talk about IP in short, or intellectual property. It is something which you create, and this is something which could be an invention, an artistic piece of work, a symbol, and this is, in general, a property of that individual or a business. If they are producing, any, say, Facebook, for example, has produced this social networking software, SNS, and the code that they have, which basically are algorithms or code which runs this particular networking site, is their intellectual property. Now, this code is protected under the law, under legislation, and it is covered under the IP law. So at some stage, if there are proprietary algorithms or, coding of the software which has been done in the case of a IT company, if you look at a services organization, if they provide a particular type of service and have a particular name, or the way or the manner in which the service is provided, and if they have no such, if that is something which is an invention, or it's truly a way wherein they've introduced this, and I talk about Deliveroo, for example, or Just Eat, or you look at Uber Eats, and they've created this kind of a business model which basically allows restaurants, participating, retailers to be able to deliver food to your doorstep. And this is an idea which has been created, and this has been patented, or is a intellectual property of the company, which is Deliveroo. You look at Uber, for example, the algorithm. There are lots of other types of taxi services which have come up, like Lynx and others. But when you look at Uber, the way they invented the whole service, which resides and works through the app on your phone, essentially is proprietary, and that is where the cost and that is where basically the intellectual property comes in, the coding, the algorithms, the program, the software, and that is what is protected under the IP laws. So when we talk about intellectual property, we are talking in general about things like, it could be names of products. So I can't go out if I want to create a new product and I'm looking at creating a product like beans or maybe jams or whatever it is. I can't have a duplicate name saying that my product is also called Heinz Beans Manchester. But because it's a recognized brand, or it's already a brand which is used by Unilever, then that is something that cannot be used, and that would lead to if I have a similar brand or a similar way in which it is written, the calligraphy of it, then it will lead to infringements, and that would be covered or tried under the court of law under what are called the intellectual property rights. So designs, inventions, logos, written material, text, copy, trademarks are all under the remit of what is called the intellectual property. We'll cover this in a bit more detail, and there are a few slides to discuss and cover some of the individual items like designs, patents, copyrights, and trademarks under the assessment criteria 4.2 and 4M1. To give you a glimpse into the third part, which is the important indicative content, when we talk about employment law. Now, obviously, this is a specialist area, but when we look at payroll and when we look at some of the basic, like it or not, some of the basic bits that we end up doing under the HR services or payroll side of services, when we look at dealing with our clients, we basically, like it or not, we are actually dealing with some of the sections or some important acts under the employment law. So when we talk about employment law basically regulates or legislates the relationship between an employer and an employee. That is what is employment law. Now, in some cases, what tends to also happen is that we represent clients which are essentially not based in the UK, but they're running businesses or services, and we tend to be the only liaison office for them in the UK, or in some cases, when I say UK, what I mean by that is Great Britain. So there are companies which are registered here. They might only have one legal representative, which is the accountant. And in those cases, the accountant or the auditors would be representing the client. And in such cases, they need to be aware of some of the employment law legislations, because some of the work that they carry out could be covered under what is called the employment law. So in brief, we need to be aware of things like discrimination, anti-discrimination laws. We need to be aware of things like health and safety legislation, minimum wages, working time directive. We need to be aware of, say, pensions now. So when you do payrolls, one of the main things which has now become mandatory from the government is pensions, and every employer has to offer a pension to the employee, and employers normally offer a contributory 3%, towards their pension. So we need to be aware of nest pensions and the laws around that if you are involved in doing the payroll, because there'll be an employee contribution and there'll be an employer contribution. And in those cases that have to be looked at, calculating on the basis of, the threshold which is applicable, depending on the salaries and, the types of contract which employees would have when they work with different companies. So it'll be a part and parcel related to payroll, but these are the bits that we need to be aware of, things like national holidays, applying the working time directive, things like health and safety, you're looking at pensions, and also in some cases, we should be aware of things like, dismissals, or if the company goes into administration, sometimes statutory pay is payable if you've worked in the company for beyond 2 years. Then, if you're suddenly made redundant or the company goes into administration, then in those cases, under the government law, you're liable to be paid, what is called the statutory pay, and this could be maximum up to 20 weeks of statutory pay. If you've worked in the company for, say, 20 years, you would be liable to get that as a redundancy pay. So some of these things we need to be aware of, and this is only for knowledge sake. So this particular mind map actually covers that in a bit more detail, and for information purposes. But the idea would be here to, let's say, make ourselves more aware of, at least superficially, we need to be aware of some of the important acts and legislations which are directly related when we look at doing payroll in employment law. So any questions on this so far? Okay, so if there are no questions, we'll go into the individual assessment criteria. The first one talks about the requirement of data protection regulation. Now, as I mentioned initially, that the data protection regulation has 6 core principles, and these 6 principles are highlighted here. Now, if we need to go into the details of what is the Data Protection Act, we can go into what is called the Data Protection Act, and if you type that, normally you'll be looking at going to the .gov website, and that .gov website essentially would, take you into a bit more detail for understanding, what does this particular act actually entail. Now, there are 2 sites. If you want to look at the longish version of the full version of the act for your reading and understanding, then obviously go to the legislation.gov.uk. But if you're looking at understanding what is the act in short and how it is important for businesses and organizations, then the .gov website /data protection is a good site to go to. Now, this particular site clearly highlights, how organizations or businesses can actually collect data, use data, store data, and in some cases when they store and retrieve data, how it can be stored, how it can be retrieved, are there, requisite levels in terms of permissions, or, some sort of restrictive permissions which apply, which ensure that the data does not fall into the wrong hands. And last but not the least, if there is a request received from the client or the customer for them to be able to remove that data, then there should be a procedure through which that data could be safely deleted, could be safely trashed, and that is what this particular act will essentially cover. Now, when we look at data, and when we talk about data in general, I've explained the basics of it, but when we talk about personal data could be any form of information that you would collect about the living individual, and that information is capable of relating that information that you collected back to the individual. So if I know the name, I know your date of birth, or if I, in some cases, know your address, then that is collecting personal data. Now, in the case of accountants, we might also have things like the national insurance number. We might also have a payroll number, or the the reference that we normally see, the RTI reference on the pay slips. In some cases, you would also have access to the pay or the salary being drawn or the wages being drawn, and the amount of tax the client is actually filling, because you'll have access to his P45, P60, or at the end of the year when you do P60s, you have access to this information. So all this part of it is basically related to personal data. Things like, a lot of us may not be aware that when you talk about data, your religious beliefs, your political beliefs, your ethnicity, your nationality also constitutes, data about yourself. So when we talk about, things like sometimes when you fill up forms or you collect information which says, do you have any disability? In some cases, some forms also collect whether you're male, female, other. You're not wanting to declare. Recently, I think all of us participated in the census, isn't it? In the UK, at least, all of us participated in the census. And when we see that this data was being asked to be, provided through the internet, if this was not provided under the conditions, there was even a fine of up to £5,000, or if you were trying to conceal information, up to £1,000, because the government would like to collect data on how the population and the trends in population in the UK have, grown in the last 10 years. So all this actually constitutes what is called, personal data. Now, what does the Data Protection Act actually entail? This means this act basically talks about how you can use this personal information when you're using it for business purposes. If this is information about a particular individual, how does the organization or the business use it? And in some cases, how does the government use that data? Now, There are ways and means through which this data can be collected, and those are those 6 fundamental principles that the data has to be fairly collected. It cannot be all unlawfully collected or collected by deceit. You have things like, you have to be explicit about why this data is being collected. You have to specify reasons, and in some cases, when you look at that, if you're not happy with the collection of data or is no longer needed, then there should be a way or an outlet through which this data can also be released or, destroyed, from the system or removed from the system. Now, what did GDPR bring in? So we know that the Data Protection Act of 1998 was already, taking care of some of these basic bits under the 6th principle or the guiding principles which have been written. Now, what did GDPR introduce? Now, GDPR has introduced 3-4 things. Number one, the European Union essentially brought out a legislation which meant that the data about people within the EU, so in this case, our own version of the Data Protection Act of 2018 means that if you have to capture data about UK individuals, they'll have to keep that data within Europe, and that data cannot go outside Europe. So things like, when we use Facebook, Twitter, we use some of the applications like the Apple Store or the Google Android Play Store, whatever data they collect as statistics or as our behavior in terms of what we are downloading, using, all has to reside within the European region, and that data cannot be shared outside the European geography until unless relevant permissions have been taken. So this was one of the main things which basically was brought in, that data originating out of the individuals or members of EU, a citizen of EU, should stay within the EU and cannot be taken outside for any such purposes like marketing, sharing. So even if between subsidiaries they have to share the data has to be stored within the European Union. The second bit was that if this data, for example, had to be removed or had to be updated, collected, distributed, then the organizations need to have what is called a DPO or a data protection officer, and that person is responsible for ensuring the safety of that data, and the access to that data has to be restricted or should be having restriction in terms of the access level requirements within organizations. So imagine if you have a big company like Apple, Google, or if you're a big business with 50 employees, you have lots of data that you generate, and that data should only be accessible by people with relevant permissions at relevant levels, and that should not be in the open domain. So the data was required to be kept secure, and with security, along with that, the accessibility of that data was classified with people who have relevant permissions. And last but not the least, the creation of the data protection officer was a mandatory requirement within all organizations, whether you're a one-man business, you have 5 employees, 10 employees, somebody has to be a DPO within the organization, and that person is ultimately responsible for the storage, retrieval, distribution, and usage of that data within the organization. So when we look at the data protection rules and regulations and the 6 principles, GDPR proposed similar principles to what, and they upgraded the principles, of the Data Protection Act of 1998, because when we had this act introduced in the UK or elsewhere in other countries, you would normally see that the proliferation of data on the internet had not happened, in the digital form had not happened. So that is where this act had to be updated, and the GDPR side of things basically now includes data in the digital format. So when we talk about, if you remember, I think I'm not too sure, but some of us who remember that when we were growing up in the 90s, we used to have what is called the Sony Walkman, or some sort of a cassette player, and we used to listen to songs and other bits on a cassette. Now, come the Apple iPod in 2001, 2002 onwards, some part of this started to go on to a digital format. And then when the albums, and if you look at just the music side of things, just to relate it as an example, we see that a lot of data started to be created or stored in a digitized form. So one of the things which GDPR addresses is that it addresses that there should be stronger legal protection for data, and that has coverage now for data in all types of formats, whether it's paper, online, on the internet, or any form of digital content. There are things which now relate to within this act and ensure that all forms of data can be protected. Now, apart from this, when we look at collecting data, we need to make sure that we are getting the required consent from the individual. You will generally see that on forms, electronic, if you send out agreements or contracts using e-document sign or any other electronic service, when you send out contracts, when you ask forms to be filled on the website, or when you collect data, sometimes you would see that there's a checkbox which normally appears, which basically says you agree to adhering to all the compliance guidelines and why this data is being collected. And sometimes some individuals would know, even if they go in and are very particular to go and read the fine prints to see, okay, what all will this be signing away. So sometimes you use the term, you're signing away your life, or signing away everything, because when you check that box, there are lots of fine terms and conditions, and the collection of data under those fine terms and conditions, or fine print as we call it, which are basically terms and conditions, is being simplified so that the main points have to be clearly declared in terms of why the data is being collected and what the data is going to be used for, and a consent needs to be taken before this data can be actually collected. So this bit is the bit that we need to understand when we talk about the assessment criteria 4.1, which talks about the requirements of the data protection legislation, the Data Protection Act, and what all can be collected, how it can be collected, how it can be shared, and what are the main elements which have been which we have seen have been brought across in terms of changes from the Data Protection Act of 1998 to the GDPR, inclusion of GDPR into the Data Protection Act of 2018. So any questions on this so far?
Everything is clear. Thank you very much. You nicely explained everything.
Okay, so let's go into the second assessment criteria. The second one talks about explaining how intellectual property can be collected, or protected. Now, when we talk about IP in general, we basically straight away look at what comes to your mind is you look at thinking about things like trademarks, copyrights. You talk about patents. You talk about things which are going to be unique, things which are going to be precious to the business, things which are going to add to the goodwill of the business, things which are going to allow you to create revenue, or your clients would basically be looking at that this is something which is materialistic. It could be virtual, non-virtual. It could be lying, or being stored in the cloud. But it's something unique which allows the business to generate its activity, which is business activity leading to transactions, leading to turnover, profitability, and anything which allows you to derive that revenue time and again over a point in time would constitute, or would be constitutable under what is called the intellectual property. But when we look at the broader definition of IP or intellectual property, we basically, what we mean by that is that there are laws which have been created which allow us to take legal action against an organization, business, or an individual if you feel that that particular content, design, logo, trademark, or anything which is unique to your business as a product or a service has been duplicated, has been stolen, has been compromised. Then in those cases you would look at the use of IP or IP law coming into being. Now, when we talk about the different types of let's say IP or intellectual property, they tend to be of 4 or 5 broad types. And in some cases, when you look at applying, or basically looking at filling in an application or applying for those, in some cases you would get de facto, coverage, because this is either, created under the music. So there are certain categories in which this protection, of the intellectual property applies automatically. So things like music, art, any form of invention, a scientist has created an invention, or a company or an organization has come up with something unique as a service, they would be automatically covered because that is the reason of their existence. So that is what they actually create, or that is what they've actually uniquely created. So when we talk about the IP law, we talk about how protection can be applied to some of these distinct features, services, products, or goods. Now, under the types of production which we can look at, say under IP law, there are 5 broad types. One of them is copyright. So when we talk about copyright, we're talking about copyrights, which means, if I talk about one of the famous, selling authors, of the books, when we talk about, I'm referring to, the famous UK author, which is basically written the books, Harry Potter and things like that. When we talk about her, you normally see that the stories or bits that she has created, essentially would be the ones which you would normally see that, this is her IP. So when we talk about Harry, the novels that she's written, you would see that if this is not taken into account and is allowed to be replicated, copied, distributed without her permission, then she would lose out on, a lot of royalties or, revenue in terms of, the work that she has actually created. So when we talk about J.K. Rowling's and the books and the art, the bit of work that she has done is proprietary to her. So when an author writes a book, or when they create something which is going to fall under, literature or literary work, they would be automatically copyrighted or, protected. Then you look at art, photography, films, TV, music, web content. So if you go onto a client's website, you can't just copy and paste that copy bit of it, which explains what they stand for, what is their ethos, and then create your own website. That copy or the write-up which has been created by the company is by default, copyrighted. The second form would be design rights. Sometimes you would see architectural designs, you look at, monograms, you look at logos, and they would be shapes of objects which are again going to be, covered under what are called design rights. Now, in this case, it does not provide, in some cases, automatic protection, because if it is not unique or if it has not been applied or protected for in previous instances, then, you would need to make an application to basically get that copyrighted or protected. Now, just to give you an example here, when we look at the logo of UK Versity, and we look at the, the way it has been written and the way it has been created, this is a copyright. We have trademarked it. So essentially, we made an application to the Intellectual Property Rights Office, and after a thorough investigation, explanation of design, and going through the whole process, we are able to now use copyright C and trademark against both when they are written or when they are used as in the figurative form, like a picture, and that is copyrighted. And there's a register on which, obviously this is maintained. And when you copyright something, or when you design and cover that under design rights, because there are shapes of objects and things like that, then if it is unique and you can prove that this is unique, then this can be copyrighted and it can be protected under the intellectual property. The other ways to do this would be trademarks. Trademarks would typically include things like product names, logos. Sometimes you hear certain adwords, or you say, for example, look at a particular, let's say a radio advert that you tune into. You will see a bit of a jingle which plays towards the end. And what they've tried to create is a signature music note, which, reminds you of their advert every time you hear that noise. And that is where, those are things which can also be protected under the, the category of what is called the trademarks. And this bit of information that I've taken, is coming from the .gov website. So if you file in a trademark application, it takes about 4 months for it to be approved. And obviously you do go through a process. And in some cases, you would see that sometimes, some of your clients would kind of outsource this work to say, oh, could you do that application, our company name, or, our website, or our logo, or some of the bits that they have could be looked at applying for trademarks. Then you have registered designs. So when we look at holograms, we look at, university, holograms in particular. You look at, there's a specific term for it, which I am going to try and quickly Google to come to. You have these specific, let's say, shape or form in which, which is called the coat of arms. The term is coat of arms. Now, specifically, if you look at the various coat of arms, I don't know how many of you would have seen. This is an example of coat of arms. Have you seen or heard about coat of arms? Anybody? Okay. Obviously, if we go back to our heritage, a bit of it in the UK and obviously England and Scotland, we see that a lot of kings and royalty, or a lot of clans actually used to have what is called the coat of arms, and they were used to recognize their particular trait or their particular clan in the past. Now, if you have some of these, they have to be created and then they have to be registered. Now, sometimes coat of arms is a very specific example, but it will be covered under that. But sometimes when you look at registering a particular product shape or, a style of color or packaging or a logo, something which basically is an image, but with a specific pattern, then in those cases, those designs could also be registered. And if you have clients which basically are into architectural engineering, or for example, some of the clients which could be into creative arts, and they produce, designs. Sometimes you would see trading partners, clothing manufacturers. You would see that they basically register some of these under the kind of pattern of cloth or the design of cloth that they are using to create those fabrics. And those are then covered under what are called registered designs. Patents tend to be inventions in particular on products and services, and they are normally, the most cumbersome to get. You would generally see Apple, Google, some of the big names that we get to hear on a daily basis. They apply for thousands of patents every year, and some of these applications take up to 5 years to be decided. Most of you, if I give you a simple example from my previous life, on your smartphone, when you are in your contacts or when you check your missed calls or you're checking your photographs, if you scroll up and you flick your finger up, you normally see the scroll keeps going up for a certain point in time before it slows down. And the same thing happens when you flick it down. You will see that the photographs or the contacts or numbers are going down, but it slows down like a like a Ferris wheel at some stage, and it then shows few names or whatever it is coming up. Now this is a pattern, and this is a pattern with a company called Pixel, and they have sold that pattern, and obviously they get a lot of royalty from Apple, from Microsoft, Google, all the phone manufacturing companies, because they've invested into developing this algorithm or the piece of code which allows them to use it and create different types of animations that we use on phone. So that's a very particular example that I'm giving you, and they filed this patent, and it took 11.5 years for that to be approved. And when the iPhone came out, it was challenged by Apple, challenged by Samsung, but obviously they upheld that patent, and they receive a lot of royalty for it. So sometimes you will see companies would, get into agreements after they patent that particular invention, but they get into agreements so that the toolkits could be provided to other companies or franchises which use it in return for loyalty. And sometimes we would deal with clients or have clients which would have products and services, or if they are software companies or gig economy companies, in some cases, you generally see that some of their services could fall under the patent or could be patented. I could look at maybe a simple example of, somebody who's from Scotland and is from a particular clan. If you look at their kilt, most kilts are patented. So there are over 3,000 different designs of kilts, and, they are all patented. So you can't replicate that design without the prior permission, or basically taking out a license, or have some sort of a licensing agreement to basically look at producing that in mass scale. So these are various ways through which, let's say, the unique products, services, inventions, designs, logos, copy, or let's say certain processes of businesses can be protected under what is called the intellectual property law, or IP law in short. And there are various ways through which you can go across and get this registered and they tend to be generally what we get to see, copyrights and trademarks in particular. But if you are looking at specific fields or areas and sectors in which you have clients, then you would see maybe some of the other options also, workable, or at least see them in action when we talk about patents and, registered designs. Now, how they are protected is a bit of a process. So obviously in this task, what we are looking at doing is explaining how intellectual property can be protected. So basically 1 or 2 slides to cover in terms of understanding that, what is actually protected. Once you applied for it, you get the application approved. In some cases, if it's a symbol, if it's a registered design, or if it's, say, for example, a trademark, you get to write certain or get to use certain symbols next to it, like the C in the circle is a copyright, TM that you get to see is a trademark, and that is what actually sensitizes clients, customers, visually to say that this is something that they cannot copy, this is something that they cannot be replicating because it is protected under the intellectual property rights. Now, when we look at copyrights, which are applied in different countries, because there are different laws and legislation in different countries for copyrights, trademarks, designs, patents, you would generally see under the Berne Convention, which was predominantly, introduced in the 1971 and then further amended in 79. It allows some of these copyrights to be protected in other countries through various international agreements, and they are covered under Berne Convention. Now, generally, when you look at copyrights, if I have to say that, okay, I've copyrighted something, how long will it last for? Generally speaking, there's a minimum lifespan of 50 years for most types of written, dramatic, and artistic works, 25 years for photographs, and it might vary from 5 to 15 years depending on the type or the type of product or service which is being, protected under the IP law. Now, generally, you would see under pharmaceutical companies, mostly the patents that they apply for chemical formulas do last for only 10 years from the date they are approved. After that, they have to be then allowed to be manufactured as generic products by other companies. So in most cases, when we look at music, films, art, and literary work or artistic work, they would normally be protected for a period of 50 years. Photography is 25 years, and in some sectors, this tends to vary depending on how the IP laws are being interpreted and applied. And generally speaking, an example that I've given is pharmaceutical companies. If they protect or come out with a new formula, they can patent it, they can protect it for a period of 10 years, but after that has to be opened in some cases, to other companies, because after that the patent expires or the protection that they were applied for has expired. And how they are enforced and how they are covered under different countries is basically through the Berne Convention, which allows these, the trademarks, copyrights, designs, registered designs to be protected in different countries, because there are various international agreements which are in place and they allow for this to happen. Now, if you see an infringement, that means so if you see an infringement, that means there is copying or there is transfer, there is selling, there's replication of these items. Then in those cases, you could take your case to the Copyright Tribunal Court, and that is where some of these disputes are, settled. Now, what you will generally see is that some of these disputes which arise because of, intellectual property, they can be settled through various means. Now, if we look at certain means through which, if you just, try and visualize that, how would you try and settle some of these, disputes? Sometimes what will happen is that the companies would get into what are called licensing agreements, royalty or loyalty agreements. You would also see that in some cases, the companies refuse to allow replication, duplication, or usage of these products and services, or unique, let's say, a design or logo. In those cases, you would see they take us or seek a court injunction. And in the past, what we've generally seen is that when you look at these wars which are up between some of the large telecom companies and giants like Samsung and Apple, so they have taken injunctions in the court and restricted some of the other competitors to be able to sell those similar products, because they then take that time to be able to prove that in the court of law that the products which are being sold, manufactured by other companies, are a replica and are actually creating a dent in terms of revenue and operations of the company for the company which has basically the patent or the protection under the intellectual property rights. So you would generally see that if such kind of situation arises, then in those cases are settled in the court of law. And in some cases, you would see injunctions. In some cases, you would see, damages being claimed. In some cases, licensing agreements pursue, and in some cases, you would see royalty agreements being signed, wherein companies mutually look at resolving those issues. And then what they try and do is basically seek some sort of a royalty for the usage in return for that product and service. Now, sometimes you would see that there are basic details which you might not need to cover, but there are different organizations which is specifically two that I want to highlight. One is the European Patent Office, which is the equivalent of the Intellectual Property Right Office in the UK, which looks after, the filing of the protection under the intellectual property rights in the European Union. And then worldwide, there's a body called World Intellectual Property Organization, which is called the WIPO. And they basically look at, sometimes what will happen is that the companies which have international operations, or if you have a client which has international operations, then they might want to file a patent not just in the UK, but maybe in Germany or in Europe, and they might also want to file a patent in the US or in the Far East. So in those cases, separate applications would have to be made, and they would normally go into what is called the World Intellectual Property of Organization, WIPO, and that is where these applications would be made for seeking protection for patents, designs, trademarks, copyrights, and things like that. Now, why they are important, and the inclusion of digital assets was done within the GDPR. So when we talk about IP and IP law, you would generally see that digital assets are also included. And when we talk about, Taylor Swift, I don't know how many of you have probably read in the news that Taylor Swift is actually embroiled in, legal action with, the original LPs that she created way back, I think in 2007 or 2008, or when she actually broke into the music scene. And that is where the original, LPs, she had signed off as an agreement at that point in time with one of her managers. And that company basically has the rights to be able to sell them under what is called the digital rights. So when they sell that music on Spotify or other streaming services like Amazon Music, Apple Music, Taylor Swift does not get any royalty. She does not get paid for that. So she's now looking at, she's entered into a legal battle with this particular, company, which basically owns her, original LPs. And what she's trying to do is basically get access to those digital assets so that every time, the manager or the company which is basically, embroiled in this particular dispute for the master recordings that she had created, the person's name is Scooter Braun, and, the company that he holds has the original rights, and obviously he's demanding 300 million in return to be, given back, or giving back the original, mastered versions of, her creation in terms of music. So when we look at digital assets in particular, they are also covered under the intellectual property right, and you see this happening a lot more in current times, because under the category that we discussed, when we talked about music, films, when we talked about, recordings in particular, sound recordings, music recordings, you would generally see that these are considered as what are called digital assets, and they are also covered under what is called the intellectual property law that we need to just briefly cover. So in this particular task, what we are focused on understanding in particular is that what all is covered under the remit of intellectual property, how protection can be applied for the intellectual property, and last but not the least, what would be the various organizations like the European Patent Office, the Intellectual Property Rights Office in the UK, and the WIPO, which is World's Intellectual Property, organization, where we will need to look at, making applications should the need arise, or, if you provide these services, and that is where the intellectual property gets, protected under various provisions. And we need to be able to be aware of Berne Convention, which allows some of these rules and regulations to be enacted and followed through the international agreements in different countries. And the Berne Convention was signed in 1971, and later revisions of that were done to include the EPO and the WIPO in 1979. So any questions on this? One of the things which I would normally ask is, what is the importance of IP for businesses? So in some cases, I mentioned earlier that IP would be important for businesses, because if they have a unique service, or if they have a unique product or a concept or an idea, and that needs to be protected, because that is the idea, the concept, the product, the service, which will help them generate revenues. And if it is going to be unique, then in those cases that has to be protected, because it basically dictates how the company would perform or how the company would generate business in the years to come. And that is why IP is very important. Now, let's look at the last bit, which is basically talking about, the impact of legislation on employment. Now, this particular slide, which I talked about, and I showed that in the initial beginning, the employment law, when we look at payroll in particular, there are lots of different acts that we need to be aware of, obviously not from an HR perspective, but from a perspective of, looking at doing payroll and payroll-related activities. So some of the acts that we need to be aware of are things like the Equal Pay Act, the Employment Rights Act. So proper contracts are formed. Hello, Mr. Jima. Proper contracts are formed.
I'm sorry, my internet has been terrible.
No problem. Thanks for joining. Now, when we look at the National Wage Act, you look at leave, for example, when they're applied, pensions when they're applied. You look at maternity leave, which used to be under the under the guidance of Maternity Act, 26 weeks. Now has amalgamated to maternity and paternity leave. So the father and the mother could both take technically 26 weeks, and the other would take 26 weeks. So that means they could probably take a year of holiday under paternity leave, and that would still be covered under the statutory maternity and paternity leave pay. So those are bits that we need to be subtly aware of, specifically when we talk about some of the legislations which are related to employment and their impact from our point of view on the payroll. So things like pensions have become mandatory from 2017, when government introduced this legislation of nest pensions, that employers need to provide pensions to all employees if they don't have a saving. And in some cases, smaller businesses were initially, there was a phased out time schedule which was introduced by the government. So in the first year in 2017, 1% contributory pension was supposed to be made or paid from the employer. In 2018, it became 2%. In 2019, it became 3%. And then the minimum contributions which the employers have to make is up to 3%. And then the employees can make that similar contribution or higher under these Pensions Acts of 2009. So when we talk about types of employment, there are two different types. One is you're employed, you're working under a contract, you're a permanent employee, and the other would be you work as a contractor, you work as a self-employed individual, you work through a company, or essentially you're working on a contract. And when we look at the 0 hours contract, which was also introduced, a couple of years back, and where we see the conventions, being challenged. For example, Uber has lost a case in the UK High Court, I think, or the Supreme Court, wherein they have to treat Uber drivers as employees, and they're entitled to, what you call a holiday pay and sick pay and, sick leave and things like that. And the same case goes out for Deliveroo. So there are companies, obviously, if you have clients, all the more good. But generally you would see that some of this, pans out and very closely works in relation to what we do and work when we provide some of these services to small, businesses, or in general medium businesses. Now, some of these acts is what we need to be able to cover. So what we need to be able to do is discuss briefly some of these acts, and we need to, that is where it will be covering the requirements of this particular learning outcome, which talks about, the legislation relating to employment. So there are lots of these acts, as you would see in this particular slide, but some of them, for example, health and safety, might not relate to us directly, because under health and safety regulation, the employer is liable to provide safe premises, which is safe for not just employees but also employers. You might need to have things like a public liability insurance. You might need to have public liability insurance, or in some cases a certain value of that insurance which is required, and limited liability insurance is required, so that if there are accidents or other things which can occur, or if they occur within the office premises, then employees, guests, visitors, are covered under that particular part of insurance. You also have indemnity insurance, professional indemnity insurance. A lot of your clients, in some cases, some of my clients have taken out the personal or professional indemnity insurance because their businesses provide advice, guidance, and information on the basis of which some of their clients actually make decisions. So if their information and the data that they provide is incorrect or inaccurate, they can be sued back by their clients or companies, because on the basis of that information they are making decisions, and if the decisions are to go haywire or go, sorry, if the decisions are to not work out, then in those cases they can be liable under professional indemnity, and that is where some clients would also have, what is called the professional indemnity insurance. So this is a vast area in terms of looking at employment law, but what we need to be able to cover in this particular task would be certain basic acts that we need to be aware of. And what I've done is, in a few slides, basically listed some of these acts out. So some of these acts include the Employment Rights Acts of 1996, which basically looks at how employees can be dismissed, what is the procedure around redundancies, the minimum notice period which has to be given. In some cases, we call it garden leave, or how do you terminate a contract. So if you do provide services wherein you are looking after contractual side of things in terms of drawing up employee contracts and things like that, or contracts for suppliers, partners, credit agreements, then some part of these would fall under what are called the the Employment Rights Act of 1996. The other thing we need to look at is the Equal Pay Act of 1970. So here we need to, this has also been in the news for a number of reasons. That if you recall, BBC and some of the organizations have been in the news that they have differentiation in terms of the pay between male presenters and female presenters. So sometimes, as let's say people looking into the payroll, if you spot an anomaly and you would say, okay, you have some employees at this doing the same work at this pay, and some employees who are doing the same work at this pay, and if there's a differentiation, and then sometimes if these differences are used to create differentiation on pay, then this would be covered under what is called the Equal Pay Act. So that does not allow you to pay differently to different employees on the basis of their background, their experience, or the let's say the race and demographics side of things, and that is what is covered under the Equals Pay Act. Then the two others which are very important for us is the National Minimum Wage Act of 1998, which obviously imposes minimum levels of pay. This, as we know, because if you see the successive budgets which come out, there are increases in the basic or the national minimum wage, which is, the thresholds have been increased. In this year's budget also, the threshold has slightly gone up. And what we need to be able to ensure is when wage slips and salary slips and other things are being drawn in, if people are working at the national minimum wage, we are applying the right, correct levels in terms of, generating the payroll. So when we look at from 1st April 2021, this has moved to £8.91 for people who are 23 and over. And obviously between 21 and 22, 18 to 20, people who are working as apprentices and people who are under the age of 18, and are, there are different brackets. So obviously the national minimum wage structure applies. And what we need to be able to do is ensure that if payroll is being generated and you have apprentices, employees working at the national minimum wage, then these are the standards which are applied or are referred to make sure that there are no anomalies and obviously no mistakes which can happen on this side. The other bit that we will also look at is statutory redundancy pay. Now, under the let's say the Employment Act of 2002, what we generally see that all companies, if they have to look at redundancies and if they make employees redundant, then they will have to pay statutory redundancy pay, and this kicks into for payments if the company even goes into administration liquidation. The administrators which come in would put these into what are called preferential creditors, and employees would be still liable to get the statutory redundancy pay from the redundancy office, which is under the government remit. And this starts to apply when an employee has worked for the employer or within the organization for a minimum period of 2 years. And there is a bracket through which we work through this. So if we look at employee who has worked for 2 years or more, they are required to get minimum statutory redundancy pay of 1 week. Anywhere between 2 to 12 years, it will be 1 week for every completed year of service, and anything over 12 years would be for minimum of 12 weeks pay that the employer would be liable to pay if they are making them redundant, or if they have to do statutory redundancies, which generally would happen if the company operations are being wound up, going into administration, liquidation, and in some cases, the operations of the organization being terminated, fully. Now, there are other bits that we also need to briefly understand in order to relate this as an impact. One would be to understand what are short-term and temporary staff layoffs. So anybody who works, for example, for an employer, and when we look at zero-hour contracts, or what you normally see in the contracts, the notice period has to be specified. Now, in employments wherein notice period is less than 4 weeks, you generally see they tend to be rolling contracts or, people who are working on self-employment basis. But in some cases, when you see people working for an employer or an organization for over 13 weeks, then, and if they've worked for over 6 non-consecutive weeks, you would generally see that in those cases, the redundancy or the minimum termination notice period has to be between 4 to 6 weeks. And that would mean that the employer cannot dismiss an employee without, providing that particular notice. So there are various laws which govern zero-hour contracts, short-term contracts, temporary layoffs, statutory redundancies. And what we would want to do is basically just go through some of these slides to have a bit of a broader understanding in terms of how this would pan out, so that you have some information as far as the legislation relating to employment is concerned. When we see organizations doing large-scale redundancies, so there is, under the Employment Act of 2002, this is covered that if you are making in one go more than 20 redundancies, then the consultation has to be done by the employer. And in this case, sometimes consultation is done by the employer, or in some cases through the union. And if the consultation does not reach a conclusion, then the employees have the right to be able to take this through ACAS or the arbitration service, wherein they would then look at this process of consultation to see why these redundancies have been or are being made. Now, and in some cases, there is a minimum time limit which applies, that the consultation needs to last, if it's between 20 to 100 or 20 to 99, at least 30 days have to be looked at in terms of length of consultation. If it's more than 100, then it has to be at least 45 days before the dismissals actually happen. So if I look at British Airways. Now, during the height of the pandemic, you would see British Airways, Virgin, a lot of these large companies, employers basically announced multiple level of redundancies. So British Airways was the first one which started to make redundancies, and they said they will normally they will do away with 12,000 staff in terms of pilot, air hostesses and ground staff in order to look at dealing with the pandemic. And that is where when the government actually started to come out with a furlough scheme to say that, in order not to have these redundancies, they would support businesses by allowing employees to be furloughed and would pay a certain amount of, cover a certain amount of salaries or wages, depending on, the duration or the employee's salary. So when we look at such consultations, which tend to happen, they involve unions. There is a certain minimum time period which needs to be looked at for these consultations. And if these consultations do not result in, say, for example, an amicable solution, then the employees are able to, basically take it to the ACAS or the Advisory Reconciliation and Arbitration Service. And in some cases, these cases can also land into the employment tribunals because, in some cases, employees would feel that they have been unfairly dismissed. So in those cases, the unions and ACAS would mediate. And if that mediation does not come to any conclusion, then the employees can also take their case to the employment tribunal courts. And that is where we need to be aware of in terms of how legislation becomes important. When we look at dismissals, when we look at redundancies, when we look at contracts in general, and the areas in the contract that have to be very clearly specified, things like the notice period, we look at statutory redundancy pay, we look at dismissals. If they have to be done, they have to be done on certain grounds. It could be disciplinary dismissal, it could be, and there have to be specific reasons given. Sometimes when employees are if they feel that they've been unfairly dismissed, organizations have to give specific reasons of why these dismissals or why this dismissal is happening or is happening on a large scale. Then the consultation has also to be applied in order to ensure that the employer and the employee both are dealt fairly under the Employment Act of 2002. So that would basically, and there are lots of other, bits, and that's what I've covered in the backup slides. So if you want to read into things like what is an unfair dismissal, what is a constructive dismissal, equal opportunities legislation, why it is important, these are some additional slides which I've tried to cover, but they would generally fall in the remit of, HR. And in some cases, when we look at the indicative content which has been given in the unit specification. So what I've tried to do is basically cover each of the bullet points to ensure that you have at least sufficient knowledge under the employment law section of it, and all the points which we have, what has been mentioned in the module content are actually covered and have given you some, basic information and knowledge about how the impact of, employment law impacts legislation in general. Is that okay?
Can I ask a question?
Yes, go ahead.
I'm sorry, I came in late because my internet was problem. I don't know when you started, but I don't know whether you covered areas such as the IR35, which relates to people in private practice or people who are practicing or contractors and so on. IR35, have you explained what it means? What does it mean?
See, AR35, if we look at AR35 and AR36 that we look at, typically would relate to, in some cases, when we talk about employment legislation and we talk about these, 0-hour contracts. So this is something which is very specific when we talk about, to people who are essentially working as contractors. So there was an important piece of legislation which basically underwent a change, wherein when you look at doing payroll, what some of the employers or people who have been working through a limited company or through, say, for example, on a self-employed basis, if I have my understanding correct, if they worked for the employer for consecutive, 12 weeks, then in those cases there were some changes brought across into the legislation and the employment law, which basically meant that some of these would have to be treated as, employees within the organization. And this is where the, some part of this pay structure side of things has an impact on, the employees. So when we talk about whether they are actually employed under the 0-hour contract, or they are employed, or they are considered to be deemed employed under that particular contract. Now, that bit is not actually covered anywhere in the indicative content. So it's not related to this particular unit at all, or under law for accounting. That is specifically, related to the HR side of the legislation, if I understand that. So that's why I've not covered AR35 or IR35 in this case, because there were changes which were done last year, or they came into, I think, last year on the 4th or 6th of April, and that is where the this had to be declared that if your working status is a contractor, or you're working through an hiring organization, or you're working as a supplying contractor, and that is where your employment status had to be looked into, whether you're self-employed, working through a contractor, or through a limited company, and how you basically look at declaring your income. Is that correct? Is that something which you are referring to?
Well, yeah, partly correct in that it relates to somebody who is working in a public office and at the same time contracting. In other words, if you are working in a public office and you have a limited liability company, so what the IATHE now is saying is that you either register yourself in the payroll of that company, or you stop completely from that company. You have to distinguish yourself. So companies are meant to recruit, take in contractors in their own payroll, deduct taxes, because most of them were not deducting complete taxes and they were not paying properly. So companies are now meant to accept these contractors into their payrolls and deduct appropriate taxes and pay to HMRC. Alternatively, they could also align themselves to umbrella companies who could who could pay. Companies would pay umbrella companies will pay HMRC and pay the contractor if they insist on work for public enterprise.
That is correct. So essentially it was legislation related to contractors, wherein a lot of companies had employed large-term contractors, and what they used to do is renew contracts after every 12 weeks. And that is where the government brought in this particular legislation or amendment to the way in which what they said is that if you issue 0-hour contracts, or if you have employees working as contractors, as suppliers, or as working through an independent company for more than 6 weeks, or more than 12 weeks, then you are actually responsible and liable to take them on roll. You should be offering them employment. They should no longer be working as contractors. If they work through umbrella companies, as you mentioned, then they should be held liable to pay the minimum, tax which is required to be deducted at source, the TDS, so National Insurance Contribution, and the PAY which is due. Yeah, that bit is, I'm aware of that, and obviously, this bit is not covered under this particular unit for some reason. So,
right, okay.
Although it comes under, what I mentioned in this particular learning outcome in the start is that, this particular outcome basically concentrates on you understanding some of the legal side of ramifications, or, the legislation which is applicable when you do go out and provide, these professional and business services as a financial or as a management accountant. So as an accountant, essentially. But some of these would not fall into your remit if you don't do payroll, or if in some of these would be additional services that you might offer to your clients. And in those cases, you might be required to be aware of having some bird's eye view, or let's say have some knowledge about some of these act and legislation which clearly applies within the HR remit. But because some of the softwares that we use today, like Sage, Xero, QuickBooks, you look at some of the other softwares, they have payroll integrated into it. So when you look at payroll, things like contracts, pensions, whether it's part-time, full-time employees. You look at some of the codings which we tend to apply when you take an employee into a payroll, like the P45, the P46, Part A, B, C. The knowledge that you have on that side is the bit that we have looked at in this particular learning outcome. So it focuses on making you aware of the three broad areas which would be covered. And these three broad areas tend to be, you being aware of things like data protection, where it entails, how it entails, what is your responsibility in some cases when you're having the data that you maintain, not just on the personal side, but also on the business side for the clients. You look at some of the intellectual property related law, which is again information sake purposes, that some of your clients might have product services or offer products and services in the form which could be unique, proprietary. They could be on the cloud. When you look at the gig economy, in those cases you might want to sensitize your client about the protection which is required to be applied under the intellectual property law. And in some cases this work might be outsourced to you as an accountant. So when you apply for trademarks or let's say copyrights and things like that. And then the employment side of things, which is more or less directly related to payroll, because when you look at contracts, in some cases as accountants, we also are given the additional responsibility of running an additional service. Like we do payroll, we do contracts as well. So there's a standard version of the contract that we maintain for part-time employees, full-time employees, and ensure that, the compliance is there with things like national minimum wage, pensions, which are important now in terms of employer and employee contribution. And then we look at, things like if there are bits and pieces, the client or the client business goes into liquidation administration, and if it has employees, then, statutory redundancy pay, and, key bits around how termination can be done, or when we talk about dismissals, redundancies, statutory redundancy, the idea is you should be aware of some of these things, but might not be offering them as direct services, under the banner of being an accountant. But sometimes with payroll related information, you might be required to hold such information and have a bit of knowledge. And that is what is covered under this particular learning outcome, which is talking about, understanding the areas of law which could affect business and some of the professional services that you offer.
Okay, thank you.
Okay, good stuff. So any other questions on today's discussion? So this was the last learning outcome, wherein for learning outcome 4, wherein we've covered, basically areas which can affect your client's business, or at least you should have some understanding related to, things like data protection, intellectual property rights, and law, and then latter being the employment legislation and employment laws. So let me go one by one. Are there any questions at your end?
No, I don't have any questions. Thank you.
Okay, that's great. Are there any questions at your end? Are there, Udesh, any questions at your end?
No questions from me. Thank you.
Right, okay. That's great. So next week, we are going to be looking at doing a session on discussing the assignment of this particular unit. So if you go through the assignment brief, it is going to be up on Moodle already. So if I quickly just give you the assignment brief on Moodle, the idea would be to try and do that and then have any specific questions that you would have that we can actually take up, in our discussion of the assignment brief. So let me just switch over and show you very briefly, the brief, which is what we're going to discuss next time. So go into law for accounting. Law for accounting, go down. So the second document that you see here, Law for Accounting Assignment. That's the one that we're going to be discussing next week. So if we have a read through on this particular assignment brief, and we'll have a detailed discussion on this next week, same time. Okay.